This courtroom hearing spirals into chaos almost immediately, as Judge Simpson comes face to face with a defendant who believes the law does not apply to him. Daniel Mio, charged with resisting and obstructing a police officer, walks into court representing himself, and from the very first moments, it's clear this is not going to be a normal proceeding. Instead of addressing the charges, Mio launches into familiar sovereign citizen arguments, questioning the court's authority, challenging basic procedures, and refusing to engage directly with the judge. Judge Simpson wastes no time issuing a blunt warning: representing yourself is dangerous, and Mio will be held to the exact same legal standards as a trained attorney. No shortcuts. No special treatment. As the hearing continues, confusion and frustration grow. The prosecution explains that discovery has already been provided, yet Mio insists, without evidence, that critical information is being withheld. He even references a writ filed with the Court of Appeals, conveniently ignoring the fact that it was already dismissed. The judge attempts to move the case forward, but Mio's evasive answers, improper filings, and refusal to follow procedure only make things worse. What truly shocks viewers is Mio's courtroom behavior. Chewing gum, speaking over the judge, and dodging direct questions while treating the hearing like a personal debate rather than a serious criminal proceeding. The judge ultimately sets firm next steps, scheduling an in-person preliminary examination and making it clear that the court will not bend to pseudo-legal theories or courtroom theatrics. With mounting allegations, reported custody issues, and a judge rapidly losing patience, this hearing becomes a textbook example of how not to represent yourself in court and a dramatic reminder that courtroom authority is not optional.
Good afternoon, Your Honor. Daniel Magoo.
All right. Mr. Gu, you are representing yourself. I do have to apprise you that you are before the court on charge of resisting and obstructing a police officer. That is a high court misdemeanor, or what technically is known as a high court misdemeanor, and or felony punishable by up to 2 years, $2,000 fine plus court costs. There are great perils in representing yourself. In this, you have to understand that I am going to treat you the same as though you know the laws and the rules of evidence. I will not treat you worse because you are not represented. I will not treat you better or grant any favors or try to clarify anything for you. If for whatever reason during any point in this proceeding you wish to be represented by counsel and cannot afford to hire counsel, counsel will be appointed to represent you. As I have in the past hearings asked you to acknowledge what I've said, I'm going to only indicate that I believe that you understand English. You believe that the words that I have said to you are understood, so that we don't get into, you need to remove the gum from it.
Thank you.
So I will not ask you to acknowledge. I will presume that you do indeed understand everything that I've said. Now, having said that, what are we doing with this case?
I'd like to move for evidentiary hearing or prelim. Yeah.
You wish to have a preliminary examination?
Preliminary examination, yes, sir.
Would the people have their witnesses available the second?
We can try, Your Honor, but before moving toward that, would the court be willing to make its inquiries about discovery? I am aware of the defendant having filed a writ of mandamus with the Court of Appeals of the state of Michigan.
Yes.
That was subsequently dismissed without prejudice by the Court of Appeals.
Correct.
Contained within that, though, there are allegations that my office has violated its Brady obligations and has not provided sufficient discovery. So I'm not sure if we're ready to move forward to preliminary exam. The defendant is saying that he doesn't have all of the discovery. That is the concern of the people. The record I feel compelled to make at this time, though, is that the people have provided, I do believe, complete discovery to the defendant, and I believe that some of the representations that were made in this writ of mandamus that has been dismissed appear to allege that things that have already been denied by this court should be produced. Furthermore, the defendant filed a motion with no notice of hearing attached to it. So there's an outstanding motion in this case as well, no hearing date scheduled. So I'm hoping that we can sort of reconcile both of those things as to whether or not discovery is something the defendant's prepared to move forward, and if he ever intends to file a notice of hearing to go along with the motion that I received in this case, on 11/22.
Mr. Magoo, your response.
My response is that I thought this was the hearing that we were setting for the motion. So if I have to set a motion for a notice of hearing for that motion, I will do that today, Your Honor, promptly.
What about discovery?
I'm ready to move forward on my what I meant by my discovery comment was that there's still no exculpatory evidence as far as that I did anything wrong as far as anything that they've submitted. So if it was improper for the wording, Your Honor, I apologize, but my ultimate goal is have the prosecution present their evidence against me.
I'm going to indicate discovery is complete because I don't know what you're saying, because what you just said regarding discovery didn't make any sense. As it regards the motion, we will hear the motion the motion will be heard on date of exam.
Thank you, Your Honor.
Deal with it at that point in time. So the people would have their witnesses available on the second.
We can try for the second, Your Honor.
Preliminary examination in person, January 2nd, 2025, 12.
Yeah.
12 noon, that is before me.
Thank you, Your Honor.
And continue.
The courtroom is quiet as Judge Simpson takes the bench, but that calm doesn't last long. What should have been a routine procedural hearing quickly turns into a tense and exhausting confrontation between the court and a defendant who appears determined to fight not just the charges against him, but the authority of the legal system itself. Daniel Mio stands before the court charged with resisting and obstructing a police officer. Instead of being represented by counsel, he has chosen to represent himself, a decision that immediately raises concern. From the moment he begins speaking, it becomes clear that this is not a defendant interested in navigating the legal process in good faith. His language, tone, and arguments closely mirror those commonly associated with the so-called sovereign citizen movement, a belief system rooted in the idea that courts lack authority over individuals who refuse to recognize them. Judge Simpson addresses this head-on early in the hearing. In a firm but measured tone, he warns Mio about the serious dangers of self-representation. He explains that the courtroom is not a place for improvisation, ideology, or internet-based legal theories. Mio will be held to the same standards as a licensed attorney. He must follow the rules of evidence, comply with procedural requirements, and conduct himself appropriately. The judge makes it clear that choosing to represent oneself does not mean choosing which rules apply. Mio listens, but his responses suggest he is not absorbing the warning. Instead of acknowledging the risks, he continues to challenge the legitimacy of the proceedings. He questions jurisdiction. He avoids direct answers. He frames routine legal processes as personal attacks. Each time the judge asks a straightforward question, Mio responds with circular arguments or vague assertions that fail to address the issue at hand. As the hearing moves forward, discovery becomes a major point of contention. The prosecution explains that all required discovery has been provided. They state clearly that there is no outstanding exculpatory evidence being withheld. Despite this, Mio insists that critical information is missing. When asked to identify what evidence he believes is being withheld, he cannot provide a specific answer. Instead, he repeats generalized claims, suggesting misconduct without offering proof. The prosecutor then notes that Mio previously filed a writ of mandamus with the Court of Appeals, an extraordinary legal maneuver rarely appropriate in cases like this. That writ was reviewed and dismissed. Rather than accepting that outcome, Mio continues to behave as though the filing somehow invalidates the current proceedings. The judge patiently explains that the dismissal means exactly what it sounds like. The higher court found no basis for Mio's claims. This explanation does little to change Mio's approach. He continues to speak over the judge, reframing answers, and redirecting questions back at the court. His manner suggests he views the hearing as a debate rather than a legal process. Judge Simpson repeatedly reins him in, reminding him that this is not a conversation between equals. The judge asks the questions. The defendant answers them. Procedural issues quickly pile up. Mio has filed motions without proper notice. He has failed to follow basic filing requirements. Instead of acknowledging these errors, he argues that the court should still consider his motions as submitted. Judge Simpson explains that courts operate on rules, not personal interpretations. Notices exist to ensure fairness, preparation, and due process for all parties involved. Rather than allowing the case to stall, the judge makes a decisive ruling. Any pending motions Mio wishes to raise will be addressed on the same day as the preliminary examination. The court will not accommodate delay tactics or procedural confusion. The message is unmistakable. The case is moving forward. Throughout the hearing, Mio's demeanor continues to draw attention. He chews gum while speaking. He gives dismissive answers. He avoids eye contact. He speaks in a way that suggests he believes he is smarter than everyone else in the room. Each attempt to assert dominance or control only results in firmer responses from the bench. Judge Simpson remains composed, but his patience is clearly being tested. He repeatedly explains concepts that would normally be understood by trained counsel. He gives Mio opportunities to correct his behavior. Yet each opportunity is met with resistance rather than cooperation. The underlying problem becomes increasingly clear. Mio is not simply unprepared, he is unwilling to engage with reality as it exists inside a courtroom. He treats legal standards as optional. He treats authority as negotiable. And he treats the hearing as a performance rather than a proceeding with serious consequences. As the discussion continues, the judge emphasizes that courtroom decorum matters. Respect matters. Procedure matters. This is not about winning arguments or scoring points. It is about determining facts, applying law, and ensuring justice. Mio's refusal to adapt only strengthens the prosecution's position while weakening his own. Eventually, the judge sets a firm next step. An in-person preliminary examination is scheduled for January 2, 2025, at noon. There is no ambiguity in the order. Mio is expected to appear, prepared, and ready to proceed under the same rules that apply to every defendant who enters that courtroom. Commentary laid throughout the video underscores just how damaging Mio's approach has become. His behavior is described as arrogant, dismissive, and self-sabotaging. Viewers are reminded that this is not theoretical law or online debate culture. This is real court, with real stakes, and real consequences. The commentary also references reports that Mio has already faced significant personal fallout related to the severity of the allegations, including the loss of custody of his child. Whether directly related to this case or not, it serves as a sobering reminder that legal behavior does not exist in a vacuum. Actions in court can ripple outward, affecting every aspect of a person's life. As the hearing winds down, the overall picture is unmistakable. This is a defendant who believes confidence can replace competence, who believes ideology can override law, who believes refusing to cooperate is a form of control. But the courtroom does not operate on belief. It operates on rules, evidence, and authority. Judge Simpson's handling of the situation stands in stark contrast. Calm, firm, and procedural, he represents the reality Mio seems unwilling to accept. The law does not bend to personal philosophies. Courts do not recognize invented legal frameworks. And self-representation, when paired with defiance instead of preparation, often leads to disastrous outcomes. By the end of the hearing, one thing is clear: this case is no longer just about resisting and obstructing a police officer. It has become a cautionary example of what happens when a defendant turns a courtroom into a battleground for ego and ideology. The legal process continues, unmoved, while the defendant risks undermining his own future with every word he speaks.